everyone. Thank you for joining us today for Constangy's webinar, Navigating Workplace Policy Evolution, Insights on NLRB Standards and Employee Handbook Best Practices. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters will leave time to answer your questions. This program is approved for Sherman HRCI credit. We will be sharing those codes at the end of this presentation, so please stick around in order to get the codes. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm now going to turn it over to today's presenters, Colin and Gary.
Thank you, Victoria. I appreciate it. Good afternoon. We'll discuss today the evolving landscape of workplace policies. We're going to start with the recent significant legal change, and then we'll shift to reviewing best practices for employers by discussing strategy, establishing priorities, and building in adaptability into your employee handbooks. First of all, the significant change that I'm referring to is the National Labor Relations Board, or the NLRB, decision called Stericycle. Stericycle is a landmark ruling that represents a fundamental shift in how workplace rules are evaluated in light of employee rights. So don't worry about taking detailed notes, because we'll not only be sharing the PowerPoints with you after this session, but also be sharing more detailed notes, which should include some helpful links to some resources that I think you'll find helpful as well. Okay. Well, first of all, what's new? Let's talk about that new Stericycle decision. But first, we need a short background on Section 7 of the National Labor Relations Act. Section 7 of the Act outlines the rights of employees in a labor context, particularly emphasizing the right of employees to engage in protected concerted activities. These rights are designed to protect employees who act together to improve the terms and conditions of their employment, regardless of whether they are represented by a union. The NLRB has established guidelines for employee handbook rules to ensure that these rules do not infringe upon employees' rights to engage in protected concerted activities. The NLRB, under the Democratic majority that's now in place and following the 2020 election, has moved away from the Boeing previous standard, which was a categorical approach used since 2017. The previous approach allowed employers to classify handbook rules into clear categories, ranging from always lawful to always unlawful. And then there was a middle category of decided on a case-by-case basis using a balancing standard. Now, the Stericycle decision has abolished this framework in favor of a more nuanced case-by-case analysis with regard to all employment rules. Under this standard, any employer policy is presumptively unlawful and could be any employer policy could be presumptively unlawful if it reasonably interpreted by employees to limit their Section 7 rights, including discussing wages or working conditions. This is a significant departure from the old standard, and employers have a heavier burden in justifying their rules. So here is the standard. Here's just employer rules seen as potentially NLRA limiting or presumptively unlawful. Now, it's key that the board has cautioned employers to basically take an employee who is at the time he or she is reading the rules, the employment rules, is dependent on the employer economically and is considering engaging in protected activity. And so that dictates whether or not their reading of the policy will suggest that it's limiting and potentially prohibiting. So rules restricting rights are immediately suspect. Employers must then, if it's found to meet that first burden, the burden shifts to employer to justify the rule's existence by just showing that it supports some kind of legitimate business interest by the employer, and that there is no less restrictive alternative available. And that can be very difficult in the employee handbook context because, as one of the things we know, many of the policies that we advise employers have are important to have, we think, but they're not absolutely necessary to have. So it's going to be very difficult if it gets down to that point for an employer to show that no less restrictive alternative is available. Okay. Rules are deemed unlawful if they can't be justified on both counts. Okay. All right. Well, let's take a closer look at the implications of the stereo cycle decision. Well, the shift demands that employers more closely scrutinize their handbooks and workplace policies, more so than ever. Almost any rule could now potentially be seen as interfering with protected concerted activities. And those concerns apply to not just employers with unions in place, but all workplaces. Well, what else is challenging about this decision? It comes from an agency that I believe the HR community knows the least about and is the most political of the agencies, more so than the EEOC or the Department of Labor. I'd encourage you to watch a webinar from one of our firm's attorneys, Jonathan Martin, and I'll provide a link to the YouTube channel for our firm in the materials. And he specializes in labor and employment law and regularly represents employers who either have unions or are actively facing union campaigns. Importantly, he makes the point that recently he's represented employers who don't have any unions and have had various policies challenged by employees. Employees are basically becoming more wise to their rights and more active in advocating for themselves. So just something to look into, and I encourage you to watch the entire video from Jonathan Martin, but I have keyed you into just a 5-minute segment that is most relevant. So if you don't have the time, I'd recommend you at least get those 5 minutes in. Okay. Well, shifting from what's new, now I want to shift to best practices for employers with regard to handbook policies and the revision process. Let's address the broader purpose of an employee handbook. Most employers would probably agree that two of the primary purposes for having an employee handbook are, one, providing clear guidelines to employees regarding expectations of work rules and standards. And then second, employee handbooks play an important role in preventing and defending employment-related claims. So that's, I think, two of the most important purposes for a handbook. Keep that in mind. Okay. Well, let's talk about policy drafting guidelines from the big picture perspective. here are a few of those guidelines. First of all, when it comes to initially drafting or substantially revising your employee handbook, don't underestimate the difficulty of the process and don't go it alone. From the start of the project, build your team and define everyone's role. There will be people who will be involved in big picture policy decisions. There will be people who are involved in reading and revising the actual policies. And, at some point, hopefully you'll have an attorney review it. But bringing all those people in at the beginning should help you keep the project on task and not have it hung up at any one point because you failed to include somebody important in the process at the beginning. Okay. All right. Well, making the employee easy to navigate, in my opinion, is one of the more important aspects of an employee handbook. Let's be honest. Almost no one, if no one at all, is going to read the employee handbook from cover to cover. Typically, it's going to be used as a reference tool. When employees have questions, they'll probably go to that policy or group of policies that addresses their concern. And, obviously, one of the things that's going to be helpful is a good up-to-date table of contents. Something else that's helpful is if you distribute a handbook that has some kinds of means where you can enter a word search and go to, that provision, that's helpful to have, whatever the version of that PDF that allows you to do that, or if it's in Word, something where it makes it that much easier for the employee to use and navigate their way through the handbook. Okay, so also make sure the policies in the manual are policies that you actually follow. There's probably no easier way to destroy your organization's credibility than having a policy that is just not followed. Then that will, kind of tank your credibility with those employees affected by that. And so it's important that your policies actually be followed. Now, when I say a shorter and well-organized handbook, I want to be realistic. There is a difference between short and shorter. In all reality, a short employee handbook in today's day and age may not be realistic. And why is that? HR is more complex now than it has been in past decades. In the notes that I'll be providing to you, there'll be a link to a webinar from Eric Cook of Mineral titled 5 Ways HR is More Complex Than in Past Decades. I'd encourage you to, again, listen to the whole presentation if you can, but if you can't, I've cited about 5 minutes in particular that is what I think is especially helpful because it provides a simplified U.S. labor law history. That's an excellent summary of major U.S. Employment laws that employers need to be concerned about. And you'll notice in the last 10 years, about the last 10 years has been dominated by state and local laws. So depending on your company's geographical footprint, some of you may not be significantly impacted much because there has not been much state legislation in the states where you have employees. But if you're in states like California, Washington, Oregon, New York, or Massachusetts, just to name a few, then you've been busy with policy additions during this 10-year period. So when you review Eric Cook's timeline of U.S. labor laws, I'd like to add one that I think is to that list that I think is particularly important and will be valuable to keep in mind when I turn it over to Colin a few minutes. You'll see that one of the things he talks about is prioritizing. And one of the things I think is important in priority setting is realizing that not all labor laws are alike. In 1991, the Civil Rights Act was amended. It amended Title VII in several respects. Among the changes that were made in 1991, damages were made available to employee litigants, and damages were enhanced. And one of the key provisions was plaintiffs who prevailed would be awarded their attorney's fees. Now, that provision significantly incentivized the pursuit of these kind of cases, resulting in substantial increase in the volume of employment litigation. So that is one example of whenever there's attorney's fees for the successful plaintiff, those are the laws that you want to be particularly careful of, because there's just a higher probability that a claim will be made against an employer for an alleged violation, because there's an incentive there. There's an incentive for employees and their attorneys to pursue those particular laws. Thankfully, the law that I talked about earlier under the National Labor Relations Act, there is no private right of action for a violation of the employee handbook rule. It's still, could be an unfair labor practice claim could be brought through the National Labor Relations Board, but based on our past experience, it's that area of the law is not nearly as concerning as your race discrimination, sex discrimination, disability discrimination cases. And that the Fair Labor Standards Act is another area of the law where unpaid overtime claims are very, very dangerous, because they also have successful attorney's fees available to plaintiffs. So keep that in mind when you're revising your policies and making priorities about that. Okay, well, now I want to kind of narrow in on the drafting process more specifically with regard to actual individual policies. I think a good goal with regard to drafting a good policy is, let's start with the end point. In this case, you want to end with a policy that is designed to inform employees, answer questions without unnecessary legal jargon. Okay. Now we know that many of the policies in your handbook are there in part because of specific statutes, whether they be the Family Medical Leave Act, or they are some state version of some sick leave act under a particular state, or some municipality with regard to certain leaves of absence. Now, unless that law specifically requires employers mention that in the policy, generally we suggest that you avoid including provisions of law there, statutory sections and whatnot, and just go directly to the meat of the policies regarding who's covered under the policy, what they're entitled to, what kind of notice they need to provide the employer to take advantage of the benefit or to make a complaint. The practical things that basically follow the law, but don't get unnecessarily bogged down in legal jargon. Okay. And then one of the key things that nobody can do but the employer is make sure that the people responsible for implementation, who respond to complaints or to answer questions, are properly designated, whether it's by title, department, or actual name. You want to make sure that that's in your handbook, and those people know that they're being listed in the handbook, and have hopefully been trained about what their responsibilities are. With that, I will now turn it over to Colin, who's going to talk about some employee handbook essentials.
All right, thanks, Gary. As Gary said, my name is Colin Thakkar, and I appreciate the opportunity to speak with you all and answer any questions that you have. As previously stated, I believe Gary said, nothing in federal or Florida law requires employers to create and implement an employee handbook. However, having a handbook is very important for a number of reasons. Among those reasons is the fact that a number of policies are vital, even if they might not be legally required. They're still vital for an employer to be able to fully and effectively defend itself in employment litigation. And so I know I saw one of the questions was whether we are going to talk about employee handbook policies that you definitely should have in your handbook, and this is that point where I'll talk about that. I'm going to discuss policies that we view as must-haves in the employee handbook. Number one is an employment at will statement. This is a pretty easy one that I think I don't know if I've seen a handbook that does not include an at-will statement, but just generally, employment at will means that either an employer or an employee can end the employment relationship at any time and for any reason or no reason, so long as that reason does not violate a specific law. Montana is the only state in the country that doesn't generally adhere to the employment at will doctrine. However, even in the other at will states, an employer's or an employee's at will status can be defeated by the employer's explicit or implicit statements to the contrary. The best way to preserve the at will relationship is to explicitly reaffirm that status. Conspicuous employment at will disclaimers should be included in the employee handbook, both in the introductory section of the handbook, as well as in the written acknowledgement that the employee actually signs upon receipt of the handbook. So number one is an employment at will statement. Number two is equal employment opportunity policies. Many of you might be familiar with the Farragut-Ellis affirmative defense, and I'll give you a little background on this. There were two Supreme Court cases in which the plaintiffs accused their employers of maintaining a hostile work environment based on sexual harassment. In response, the employers demonstrated that they maintained written policies which prohibited unlawful harassment and which set forth reasonable reporting procedures. So basically, anyone who was being subjected to perceived harassment, sexual harassment or otherwise, had a reasonable procedure set forth in writing to report that and have it investigated and resolved. In both of those cases, the plaintiffs had not actually pursued or availed themselves of those reporting procedures. And the Supreme Court ruled that that would constitute a complete defense for the employer. So if the employer can show that it had a policy prohibiting harassment or other forms of discrimination, and a policy for reporting perceived harassment, and that the employee did not avail himself or herself to that policy, then that would be a bar to liability and obviously damages. This is important because even though handbooks are not required, there needs to be a written policy like that for employers to be able to properly defend themselves against harassment laws. So we recommend a general EEO policy, as well as a policy prohibiting discrimination, harassment, discrimination, harassment, a procedure for reporting perceived discrimination or harassment, and a prohibition on any form of retaliation against employees who use that reporting process or participate in investigations. Number 3, an accommodations policy. Employers are required to provide reasonable accommodations to employees in relation to disabilities or religious beliefs or practices. An accommodations policy should confirm the employer's intent to make reasonable accommodations for disabilities or religious beliefs, and set forth a procedure for employees to seek such accommodations. This way, if an employer has a general policy or procedure that certain employees claim they can't comply with for disability or religious reasons, the employer can still show that it exercised reasonable care to comply with the applicable laws. Number 4, a wage payment policy that includes an effective safe harbor provision. And I'll explain what this means by safe harbor provision. There's a general rule under the Fair Labor Standards Act that if an employee is classified as salaried and exempt from the minimum wage and overtime pay requirements, the employer cannot make improper deductions from that employee's pay, or else the employee or the exempt status would be lost not only for that employee, but also for any other employees in the same position as that employee. And it's possible, for an employer to make impermissible deductions just based on a genuine mistake. So, those are pretty severe consequences for, a good faith mistake, because if the employee loses the exemption, then the employer would have to pay overtime pay to that employee for the pay period where the improper deduction was made. And when you're dealing with salaried exempt employees, it's difficult. Usually there's no record of the specific number of hours that they worked per day. And so the employer is often at the mercy of the employee based on how much time they say they worked. Pursuant to this safe harbor law or provision, a handbook can include a provision indicating the company's intent to comply with the Fair Labor Standards Act, including procedure for the employee to report any improper deductions from their salary, and establishing a prompt review procedure. If that's the case, if that is included in the employee handbook, then the only consequence of the improper deduction would be the obligation to promptly reimburse the employee for that deducted amount. So that's, again, really important. Number 5, protected leave of absence policies. There are federal, there's federally protected leaves of absence, and protected leaves of absence are a big thing with state law. So no matter what state you're in, chances are there are some state laws that deal with protected leaves of absence, and so those should be accounted for in the employee handbook. Employers with more than 50 employees or with at least 50 employees are subject to the the Family and Medical Leave Act, which provides up to 12 weeks of unpaid protected leave per year for certain specified reasons, including the birth of a child, adoptive or foster care, care for an immediate family member with a serious health condition, or medical leave for the employee's own serious health condition. And that should be included in the employee handbook, a notification of rights under the FMLA in the case of if there are at least 50 employees. Other types of leave may be protected under state law. In Florida, this includes leave for jury duty, as well as leave in order to testify in response to a subpoena. So both of those issues should be accounted for in the handbook. Additionally, employers with 50 or more employees are required by Florida law to permit employees to take up to 3 days a year of leave in connection with domestic violence. Next, number 6, a computer usage and digital communications policy. And this seems, this doesn't jump out as something that's necessary, but in this day and age, we more and more of our workplace communications and activities occur online or electronically, especially now with the big jump in remote work after COVID. In addition, computer usage can impact the greater work environment if other employees are exposed to such usage. So it's vital for employers to establish written policies governing any electronic or computer activities. An effective policy should establish the following key points. Number 1, it should state that the company's electronic systems are intended for business-related communications and other activities, and that the use for personal reasons should be kept to a minimum. Second, it should state that all digital activities on company programs or property constitute company property, and employees should not expect a right of privacy in such activities. Next, it should state that the company reserves the right to access and review any such communications or other electronic activities at its sole discretion. And then it should state that the company's other work conduct policies, for instance, the policy prohibiting discrimination and harassment, apply with equal force to the digital communications and other electronic activities, to those employee activities. Just to make clear that that the employee, is subject to the same standards with respect to computer usage or electronic communications that they're subjected to in person. Some people get a little bold online in ways that they wouldn't in person, and so this is an important policy to address to address that and ensure it doesn't happen. 7th, and this is the final essential policy that we see, is a disciplinary policy. A disciplinary policy is important for for defending against claims of any kind of wrongful termination, wrongful discipline, and it's essential as long as it's helpful as long as it does a few key things. It should set forth a non-inclusive list of misconducts that would reasonably be expected to warrant disciplinary action. Make special note that I said non-inclusive. The policy should make clear that it is not inclusive, and it's not possible to identify every type of misconduct that would be subject to discipline. People do crazy things, and you can't completely account for that. It should also affirm the company's intent to generally issue discipline in a progressive manner, where appropriate and where possible, setting forth a standard progressive discipline format, such as verbal warning, written warning, suspension, termination, something like that that's appropriate for the company and mirrors the company's actual practice. And third, it should emphasize the employer's discretion to deviate from the progressive discipline framework where appropriate. So those are the must-haves. On the other hand, what should you not do? You shouldn't have a policy that articulates a violation of the law. That sounds obvious, but it's certainly possible. It happens, and there are some laws that aren't necessarily, intuitive. For instance, I've seen a company that had a policy stating that that unapproved overtime work was not permitted, which is fine, but also stating that unapproved overtime work would not be paid at overtime rates, and that's a no-no under the Fair Labor Standards Act. You can certainly discipline someone who works overtime without getting pre-approval, but you cannot refuse to pay wages to those people. So, another thing that is pretty common is employers often have a policy prohibiting firearms not only in the work building, but also in employee vehicles in parking lots. And under Florida state law, that is prohibited. Employers cannot prohibit employees from keeping a firearm locked in their car during the workday. And so, that just reaffirms the importance of having an attorney look over the handbook before it's issued. Gary, if you could go to the next slide.
Sure.
Thanks. All right, so handbook misconceptions and strategies. There are a number of misconceptions surrounding the creation of an employee handbook. The biggest one is that handbooks are not necessary because they aren't required by law. I think, based on what Gary talked about and what I've said already, I think we've made clear why handbooks are very important. Although employers are not legally obligated to have handbooks, the lack of a handbook can have pretty far-reaching implications on an employer's ability to defend itself against employment lawsuits, as explained above. Another misconception is that a handbook can be used interchangeably from one business to another. That's again just not the case. Outside of the handbook policies that I've talked about already as being must-haves, there are a wide range of other policies that can be included in an employee handbook, and it's important to look at the business, to talk to the key players, as Gary mentioned. Have HR involved, but also have the business unit involved, have management involved, to really get everyone's view of what is really important to emphasize, and what the actual practice is by the company. There are certain businesses easily allow for remote work, and so that might be something that's fit for a policy, whereas in the handbook, whereas it wouldn't be by other businesses. Some businesses have place, they do a type of business, have a type of employee where employee attendance and being on time is of the utmost importance. In other cases, it's just not the case, and as long as the employee gets the work done at basically a time and place of the employee's choosing, it's no big deal. And so, so for some companies, an attendance policy should be prominent. In other cases, it might not even be necessary for the handbook. You want the handbook to reflect the reality. And if you know, if the handbook has a policy that the employer does not actually enforce, or at least, or does not enforce in the manner set forth in the handbook, then that undercuts the employer's ability to stand on that handbook in defense against employment litigation. So so there's no real one size fits all handbook that we would recommend. There was a question about whether whether we recommend or what we think of a build it yourself handbook program issued by SHRM or any other company. And I don't, Gary can also speak to that in the Q&A section. I haven't seen SHRM's handbook builder. I think that can be a valuable part of the process because it's important for an employer to be cognizant of the vast array of handbook policies that could be included in a handbook, but that that shouldn't be used at the exclusion of getting all the business units involved or having it reviewed by an attorney, because it really is important to ensure for the company to protect itself in ensuring that that it's fully updated in terms of the law, what's required and what shouldn't be, or what might be legally risky to put in a handbook. So let's see. All right, Gary, could you move to the next slide, please?
Sure.
Thank you. And what I was talking about kind of feeds into this prioritizing key policies. Not all policies carry the same weight, and there are a ton of possible policies that can be included in a handbook. All of them might, there are a ton of policies that could properly relate to the business, but that doesn't necessarily mean that they should all be included. You see a situation where the more policies are included in a handbook, the less significance that might be afforded to individual policies. If you try to defend in litigation against an employment lawsuit by pointing to the attendance policy and saying, look, our attendance policy is extremely important and this employee was violating it. The employee may point to the fact that the handbook is 200 pages long and there are 100 different policies that seem to be afforded equal weight in the handbook. So you want to, an attorney I worked with before, he likened it to packing a suitcase. You want to make sure all the necessities are included, but you don't want the suitcase to be overflowing. And so our recommendation is you start with the essentials, the must-haves, and then you go through the collaborative process of identifying other policies that might not be essentials, but are, key to the business, key to what the company does, are equally important in terms of making sure the employees are aware of that. You look at policies that apply broadly to different classes of employees. There are some policies that seem important, but they might only apply to a small subset of the employee workforce, and it may be warranted to consider just having a standalone policy that you give only to the employees affected by any such policy. So go through the collaborative process, kind of rank the policies in importance, and try to keep the handbook, you know, relatively short, you know, usually 35, 45 pages is enough. For some businesses, it's just not, but that's, you know, a common volume that we've seen. And as always, you know, speak with counsel while you're doing it. All right. And Gary, could you go to the next slide, please? All right. And I mentioned that that you should try and not make the handbook bare bones, but try not to overload it. When you're developing the handbook for the first time, you're starting, you know, you're starting at square one, and you should be taking into account the reality that that amendments are going to be made in the future. You know, new policies or new rules could be identified that that you determine should be included in the employee handbook, as well as there will certainly be changes in the law that warrant revision to the employee handbook. So you know, so it's important, you know, it's important to create a final product that can be amended and added to relatively easily. You know, this can be done by having having the handbook accessible electronically, having employees, you know, providing them access and requiring them to do a written or electronic acknowledgement that they've received it and are required to review it. And then as individual policies are revised later on, you know, you might simply forward them the new policy just by itself and require them to sign another acknowledgement affirming receipt of that, while also keeping the full handbook accessible to all employees, and it can be accessible by computer. You know, you can keep a paper copy and advise employees where to review that. But it's important for the employee handbook to always be accessible to employees. Changes should also be, you know, or I'm sorry, a system should be put in place to have a regular review of the employee handbook to determine whether changes need to be made. This, you know, we would recommend that companies do this on an annual basis, just to be, because there are always, you know, the law, the employment laws are ever changing, so it's very important to stay on top of that. And that that brings my section to a conclusion. I think we're going to do a Q&A at this point and answer any questions that you have. If you haven't asked questions yet, just put them in the chat box and we'll try to get to them.
All right. Well, thank you. I will start us off with the first question. And just so you know, I've posted the SHRM and HRCI IDs that you may need for the credit. But let me get into one of the questions. What are your thoughts on SHRM's Handbook Builder? I'm not familiar with SHRM's. I am familiar with minerals, and I like it. I'm a fan of builders. I believe that, just to circle back to what Colin said, you just have to understand that a builder is going to definitely reduce your workload, but it's not going to eliminate it. There's still decisions to be made. There still needs to be a team formed. There are going to be people in your organization that you'll need to designate. There's no way that any company that's putting together the builder is going to be able to know that. So you're still going to need your team. A builder can increase the quality of the individual policies. So I'm in favor of it for those reasons. And you depending, on the level of service, you could have it like a subscription. I believe at some of them, a subscription service they'll roll out suggested policy revisions to you. And that's nice too. That's good. Now, I don't know the cost of that. I'm sure that's probably a little bit more than just getting a one-time access to it, but that is definitely another advantage to a builder. Okay, another one is we be discussing for the policy prohibiting recording or conversation with employees without notifying employees that they are being recorded in order to comply with state recording laws. And yes, Colin discussed that, but basically, there is the Electronic Communications Protected Act, which is federal, and many states have adopted various versions of that. And it's important to make sure that you have a policy in place that addresses that and establishes what are reasonable and expectations of privacy with regard to employees' information. And if they don't have that, to make them aware of that with regard to the the email accounts you have, the instant messaging accounts they have that they have access to. You need to put them on notice that those are for work related purposes. If they use it for personal related purposes, they don't have a right of expectation of privacy in that scenario. Okay. You have a list of required, not just recommended policies, along with what law requires each policy. Any prior to our list of strongly recommended policies. And again, Colin went through that. There really aren't any with very narrow exceptions in certain states with regard to anti-harassment policies in certain states. There are simply no mandatory policies, although it would be crazy to think that you could follow the law without having an employee handbook when you get to a certain size. Otherwise, you'd be it's like conducting your week without a calendar. Can it be done? Yes. Is it advisable? No. So what's the difference between an at-will and right-to-work state? At-will is probably the one that is more universally known, which means basically the employment relationship can be ended by either the employee or the employer at any time without prior notice. So an employee can come in and just say, I'm resigning, and that would end the employment relationship. And the employer has the right to terminate the employee for any reasons that's not unlawful. Of course, there are many reasons that could be unlawful. But that's what an at-will employment relationship is. A right-to-work state really comes up in the context of a unionized workplace. And when you hear that, it's somewhat of a misnomer, not the greatest phrase, but basically it means that employees can work for an employer and have the right to decide whether they join a union or allow the union to deduct dues from their paycheck. Some states that don't allow that. If there's a union and it covers a certain number of employees, then the employees may have to contribute to that union, to work at that particular employer. But if that's not the case, then that will be a right to work, state. Okay. With improper deductions leading to a loss of exemption, the obligation to pay overtime would apply to all pay periods when overtime was worked, not just the one where the improper deduction occurred, correct? Depends on the circumstances. Typically, the Department of Labor guidelines say that the improper deductions would cause the loss of the exemption for that particular pay period. However, things could get worse for the employer depending on the facts and circumstances. If the employer has engaged in activity to demonstrate that that deduction was their standard practice, then all periods could, within like a 2-year window, could be impacted. That's why one of the reasons we suggest employers have we call it safe harbor provision in their employee handbook, which talks about when deductions are allowed, the very narrow circumstances when they're allowed for your exempt employees, and provides an avenue for complaining if an employee believes that, you know, there's been some rogue supervisor who's made an improper deduction that they weren't entitled to. Okay. See, the FMLA requirement is 50 employees within a 75-mile radius, correct? Okay, you're referring to whether an employee is a covered employee entitled to FMLA leave. Yes, that's one of the requirements for an employee to have coverage. They have to work at a work site that either has 50 or more employees at that work site, or the aggregate number of employees within a 75-mile radius of that work site, you know, is 50 or more employees. Okay. Okay. The okay, if we have a main employee handbook, but then departments have also created their own policies, training related attendance, conduct, etc. Is this okay? There's nothing that prevents that from happening. There is definitely the possibility for mix-up. Again, you want to make sure that those policies don't contradict one another, and that you know, that they're consistent with one another. So you can certainly do it that way, though. Okay. How does a employee handbook differ from a policy and procedure manual? Well, the employee handbook ideally is going to have policies that are going to be very light or not really get into the procedures. You know, a procedures manual is something that may be distributed to something less than all the employees. You know, policies or procedures with regard to either a particular department, or maybe procedures that are that guide supervisors in how they handle certain issues. But basically, that is one of the main differences between employee handbook and policy and procedure manual. Okay, if your company is based in North Carolina and your handbook reflects North Carolina policies and laws, and you have a full remote employee in the state of New York, the full remote employee has signed an acknowledgement. You need to include the state of New York's rules and laws and handbook. Yes. So if you have if you're based in North Carolina and you're employing somebody who's working in New York, then yes, you're going to have to at least review and adopt policies that apply to a New York employer. There may be certain policies where, because of the number of employees you have in the state, that, or in a particular municipality like New York City, for example, that you'll be exempt from particular policies. But in large part, yes, you will have to follow New York State's employment laws, even though you only have one employee there. Okay. Okay. What is your opinion on non-solicitation policies and no camera policies relating to the chilling effect in the updated standpoint of the NLRB? Well, the no solicitation policies can still be they can still be proper, but we suggest they be reviewed to make sure that they aren't chilling with regard to particular subject matters. One of the ways that employers can potentially have a problematic no solicitation policy is they can have a no solicitation policy, but then they allow employees to post goods and services on a bulletin board or something like that, that talks about they need a roommate, or they may be selling Girl Scout cookies or something for their kids sports program or something along those lines. Well, that opens the door for employees engaging in concerted protected activity under that policy. You can't just say, well, hey, we want to keep it light. You can't talk about concerted protected activity. So that's one of the dangers of that kind of policy. But you need to have it reviewed to make sure you're not chilling that type of activity. Okay. Okay, yeah. So indicated religious disability accommodations should be made and included in the handbook. I understand accommodations should also be include pregnancy accommodation, but that wasn't included in the discussion that I heard. Can you clarify? Yes. So you definitely want to have some language with regard to pregnancy accommodations in your employee handbook, if you're going to have a handbook that includes policies with regard to accommodations and disability, especially in light of the new legislation that makes it much easier for pregnant workers to be entitled to accommodations under the law. So, and by the way, you'll definitely want to keep an eye peeled for the final regulations with regard to those as well. Okay.
And Gary, can I add
Sure.
to that? Yeah, I just wanted to make clear that was inadvertent. My failure to reference pregnancy related requested accommodations. So that should have also been there, been in there.
Okay. I'm sorry. I see that we have gone over our time, and I'm sorry we weren't able to get to all of the questions in the chat, but we will be sending out the PowerPoint and the notes to the additional resources that we mentioned, and we certainly appreciate you being a part of our webinar here today. Thank you very much.
Thanks so much.